Are you a care worker in the UK or an employer relying on overseas talent? If so, you have probably been losing sleep over the proposed overhaul of the UK immigration system. With the new earned settlement model threatening to double or even triple the time it takes to get indefinite leave to remain, the stakes have never been higher. But there might be a glimmer of hope. Recent reports suggest that some existing care workers could be completely exempt from these tougher rules. Welcome back to the channel. Today, we are breaking down exactly what these proposed exemptions mean, who might qualify, the hidden financial impacts this will have, and what you need to do right now to protect your future. Make sure you watch until the end, because the true costs of these new rules are staggering, and you do not want to be caught off guard. Let's start with the big news. According to reports from The Guardian, government ministers are currently considering a major exemption for migrant care workers already living and working in the UK. As you may know, the Home Office recently wrapped up a consultation on the earned settlement model. This new system is designed to replace the standard 5-year route to settlement with a 10-year baseline. But for lower skilled roles, which currently include many dedicated professionals in the social care sector, that waiting period could jump to a massive 15 years. The government is now waking up to the reality that applying these harsh changes retroactively could trigger a massive recruitment and retention crisis in social care. So, an exemption is on the table. But does this mean care workers are already protected? The short answer is no. At this exact moment, this is only a policy being considered, not a confirmed change to the immigration rules. Care providers and workers should not make any final decisions, assuming this exemption is a done deal. If an exemption does go through, who would actually benefit? The reports indicate that protection would focus heavily on care workers who are already in the UK, allowing them to continue on their current, more favorable path to settlement. However, the details remain completely blurry. We still do not know what specific immigration status a worker would need to hold, or if there will be a strict cut-off date for when you arrived. We do not know if the exemption will cover both standard care workers and senior care workers, or how dependents and family members will be treated. Importantly, if a worker decides to change their employer, will they lose that protected status? These are the crucial questions the Home Office still needs to answer. It is also critical to understand that this potential exemption for settlement does not reopen the doors for new overseas recruitment. The restriction stopping care workers and senior care workers from making new applications from overseas came into full effect back on July 22nd, 2025. While people who are already legally in the UK might still be able to switch into eligible care roles until July 2028, the overseas route remains closed. For employers, the good news is you can still sponsor your existing eligible workers. You just have to make sure that any extension or change of employment meets the current minimum salary requirements, which generally sit at £25,000 a year and £12.82 an hour. Now, let's look at some critical additional research that has not been widely discussed by the mainstream media, but will drastically impact your wallet if you do not qualify for the exemption. Let's talk about the real cost of the earned settlement model. If you are forced onto a 10 or 15-year route, you are not just waiting longer, you are paying much more. Every extra year you wait means another year of paying the immigration health surcharge. At its current rate of £1,035 per year, an extra 5 years adds over £5,000 to your journey per person. For a family of 4, you are looking at over £20,000 in extra healthcare surcharges alone, plus the added costs of multiple visa renewals. Furthermore, the new rules do not just change the timeline, they raise the bar for integration. Under the proposals, the English language requirement for settlement is expected to increase from the current B1 intermediate level up to a B2 level. If you are aiming for settlement soon, it is highly recommended to take your language and life in the UK tests now before the exams potentially become more difficult. So, what should care providers and businesses do right now? First, review your entire sponsored workforce. Record every employee's visa expiry date and their expected settlement date. Ensure that all job titles, duties, and salaries perfectly match the occupation codes. Keep immaculate records of hours worked and absences, because sponsor compliance is under heavier scrutiny than ever before. For employees, if you are approaching your 5-year mark under the current rules, prioritize your indefinite leave to remain application immediately. You can apply up to 28 days before you hit that 5-year milestone. Getting your application in before any new laws are cemented is the smartest move you can make. To wrap things up, the possibility of an exemption is a massive beacon of hope for the social care sector, but it is not yet law. We will be watching the government's response to the settlement consultation very closely, so make sure you hit that subscribe button and turn on notifications so you do not miss the official update. Finally, please remember that immigration rules are incredibly complex and constantly changing. The information provided in this video is for educational purposes only. Do not make life-altering decisions based solely on this video. Always consult with a qualified, expert immigration lawyer or legal advisor who can look at your specific case history, occupation code, and visa timeline to give you the best professional guidance. Thank you so much for watching, stay informed, and we will see you in the next video.